Everyone had a nice weekend and a nice day yesterday, even though we did hear we're going to have 6 more weeks of winter. I don't know if that's true in Kansas. I think the snow has finally melted after, I think we got it on January 4th, and now February 3rd, it's mostly melted. So it's a happy day. And the days are getting longer, so it's all good. Committee, we're going to have 3 hearings today. We'll first take bill requests for introduction. We have a lot, and so it's an indication of what our days are going to look like coming up. So, but I will first ask committee members if you have any requests for committee-sponsored bill drafts. Representative Ojai.
Thank you, Madam Chair. I have 2, one from the Attorney General's office, 25 RS 1027, a bill that enhances the Crime Victims Bill of Rights. And then, sorry, my computer just, here we go. Also 25 RS 1089, a bill regarding transparency in judicial decisions, brought forward. I'm submitting it to the committee on behalf of constituent Bob Cutler.
Okay, thank you. Committee, do you have any questions? Could you say the name again so we can make sure we get that of your constituent?
Bob Cutler.
Bob Cutler. Okay. Any questions or any objections, committee? Okay, without objection, those 2 bills will be requested.
Thank you.
Any other committee members? Representative Williams.
Thank you, Madam Chair. I have RS 1034, which is modifying provisions related to the series limited liability companies.
Any questions or on behalf of?
On behalf of the Kansas Chamber.
Thank you. Any objections, committee? Without objection, then that will be requested. Committee members. Representative Lewis.
Thank you, Madam Chair. 25 RS 0988. It's a mandatory reporting bill, and it requires a duly ordained clergy to report certain abuse and neglect, except when reporting would violate the penitential communications privilege.
And that's on behalf of anyone?
Myself and Representative Schlingen speaking.
Got it. Okay, any questions or objections? Okay, without objection, that will be requested for introduction. Committee, any others? Representative Martinez.
On behalf of Representative Ford Carr, I have to introduce 25 RS 1033, providing that no juvenile less than 18 years of age shall be prosecuted as an adult.
Okay, committee, questions, objections? Okay, without objection, we'll request that. Thank you.
Thank you.
Any others from the committee? Okay, how about the audience? Representative Howe, you're on the front row, so right there first.
Madam Chair, members of the committee, I would like to request bill draft sponsorship on behalf of a Kansan individual, Stephen Levette. It's 25 RS 0976. The legislation would provide that tenure at certain educational institutions shall not be defined or recognized as an entitlement, right, or property interest in a faculty member's current, ongoing, or future employment by an institution.
Okay, great. Committee, questions, objections? Okay, without objection, we will make that request. Thank you, Representative. Representative Howerton.
Thank you, Madam Chair. I'd like to request RS 0868 on behalf of Representative Leah Howe and myself, encouraging mediation in residential eviction cases and providing for sealing and expungement of court records in residential eviction actions.
Okay, thank you. Committee, questions, objections? Okay, without objection, that will be requested. Representative Tarwater.
Thank you, Madam Chair. Committee, I'd like to request introduction of 2025 RS 0871 on behalf of 3 of my constituents, Kevin Corbin, Troy Hamlin, and Brent Maroney, who are no longer with us because of a collision with a train when the driver was drinking. And the bill allows the judge to enforce child support on the drunk driver if they're convicted, because there were 7 children that no longer have fathers now.
Could I ask you a quick question? Would that be child support or restitution? Does the bill, just kind of thinking where I'm gonna,
So
with it.
last year we introduced it in, some of you guys heard it that were on corrections, and it is child support. And you're welcome to change that however you'd like.
Okay, thank you so much. Any objections, committee, or questions for Representative Tarwater? Okay, without objection, that will be requested. Thank you.
Thank you, Madam Chair, committee.
Representative. Okay, anyone else in the, from the AG's office? Yep.
Thank you, Madam Chair and members of the committee. My name is Garrett Henson, and I am here on behalf of the Kansas Attorney General's Office to introduce 25 RS 1019, and that's a bill concerning second and successive motions.
Okay, any questions, objections? Okay, without objection, we will ask for that request also.
Thank you.
Marley, you're next. Ms. Carpenter, sorry.
I am Marley Carpenter here on behalf of the City of Wichita and WPD, requesting 25 RS 0981, modifying the elements of crime of theft and making theft of property that is motor vehicle a felony.
Okay, thank you. Committee, any questions, objections? Okay, thank you. That will be requested. Mr. Molino?
Joe Molina with the Kansas Bar Association requesting 25 RS 1030, bill prohibiting the use of mandatory arbitration in insurance contracts.
Okay, thank you for that. Any questions or any objections? Okay, we will make that request. Thank you. Anyone else? Go ahead.
My name is Steve, Madam Chair and fellow members. My name is Steve Carr. I'm General Counsel for Kansas Department of Insurance, and I request to introduce RS 668, which would allow for civil penalties for insurance fraud.
Okay, thank you. Any questions on that one? It's in the 600s. That's good. It's just interesting to note these numbers, and we're up in the thousands now. So, but thank you for that. Without objection, we will make that request. Thank you for being here. Anybody else? Yes, sir. Come on up.
Madam Chairman, board members, thank you for seeing me. My name is James Iverson. I represent the National Coalition of Motorcycles and the Kansas Confederation of Clubs. On behalf of Representative Brett Fairchild, I'd like to introduce RS 1044, which this bill would relate to motorcycle profiling.
Okay, great. Thank you so much for being here. Any questions? No objections? We will make that request. Thank you for coming to committee. Okay, anyone else that would like to request a committee-sponsored draft for introduction? I don't know what the record is, but I think we're right up there. So, yeah, okay, thank you. More than that this morning? Oh, in Senate, okay, all right. Well, that'll be coming over. Some of those will be coming over. So, okay, thank you everyone for your patience with our bill request for introduction. I will go ahead and open the hearing on House Bill 2166 and ask the reviser to give us a bill brief. I will note he is the lone, are you a proponent or opponent of this, Jason? Either one. We're just going to get some information here. Okay. Okay, so we did get a memorandum about this, so if you all got that, okay. It is on the S drive in case you don't have the paper copy. Okay, thank you. All right, Jason.
Thank you, Madam Chair. As you said, Jason Thompson, Office of Reviser of Statutes. And while we're not not proponents or opponents. This is that unique bill every year that we are required by law to bring to the attention of the legislature. And we asked the chairperson to file it on behalf of our office pursuant to KSA 45-229. So this is that bill that was requested last week. You'll see in the memo, and those of you that have been around would know this, but I know some of you are new, so you may not be aware. In the Open Records Act, whenever the legislature enacts a new exception or substantially amends an exception, KSA 45-229 requires the legislature to review that exception 5 years later. Once you do that 5-year review, the exception can stay on the books for as long as you like until it's repealed. But you're required to review the exceptions every 5 years. And you'll see that sprinkled in some bills. For example, the jailhouse witness bill last week. That's why that provision's in there. We're required by law to put it in there unless you say they're not subject to 45-229. So there you go. The legislature is directed by that statute, which is in the bill and is amended in the bill, to look at 4 specific considerations. You know, what are the records affected by the exception? Who does it affect? What's the identifiable public purpose or goal? And then whether the information in the records can be obtained readily by alternative means and how it may be obtained. And that's sort of the considerations about whether you continue the exception or discontinue the exception. There have been a couple occasions where you've ended exceptions that I can recall over the years. Most of the time they're renewed. So in this case, you have 2, and they're listed in the memorandum and also mentioned in the bill. One is the exception enacted in 2020. KSA 48-962 has an exception concerning local health officers and records containing personal information relating to individuals testing positive or under quarantine or isolation due to COVID-19. As you might imagine, that's one of the reasons we only have 1 exception from 2020. It was a pretty short session. So it's a short list this year. We did find a second one that was not certified in a prior year. It was missed on a certification. And so you'll find that one in the bill as well. That's KSA 65-7616. And that one deals with licensed acupuncturists. There's a records provision in there that was set to expire, or set to be reviewed, I should say, in 2022. So it's been sitting there and went unnoticed in 2022, and it was brought to our attention. So we certified it in the letter and in the bill. So you're being asked to review that one this year as well. Those are the 2 exceptions. Nobody's here to talk about either of them, so you'll have to do the considerations yourself, decide whether those were good exceptions that you enacted or amended, and whether you wish to continue them by enacting this bill and letting those go in perpetuity.
Okay, thank you. We may have questions. Committee, do we have questions? Representative Carmichael?
Thank you, Madam Chair, and thank you, Mr. Thompson. I understand that sometimes things get missed, so I'm not at all critical about that. But if we don't review a core exemption in a timely manner or don't take any action to continue it, does it sunset, meaning these records have been open for the past several years?
Madam Chair and Representative, that is thankfully exactly the question that I asked our main open records revisor who wrote the bill, and also the boss who certifies the list to the president and the speaker. I was told the opinion of our office at this point, because it hasn't been challenged yet, is that it's not exactly a sunset. You're required to review it, but it doesn't necessarily expire or become repealed like some of those traditional sunset languages you might see, like where the provisions of this section, expire on July 1 of some year. And it's a little bit clearer that that statute no longer exists after that date. We've gotten a little more formal with those as well by actually repealing some of those things in the bill that enacts them, just so we don't have sunsets lingering like this. So at least from our perspective, the one that was missed in 2022, it sat there. It wasn't necessarily repealed. It didn't necessarily go away. But there's an argument to be made if someone would have come in for those records, they might say they're no longer subject to an exception to the Open Records Act. And we would have an interesting court case on our hands. So we don't have a firm answer, but at least in our opinion, it was still on the books. And it's being reviewed and renewed now, and that's what I was told, kind of our position.
The reason I ask, Madam Chair, is if in fact something is sunsetted and records are out in the public domain that shouldn't be, we probably ought to think about making it effective upon publication in the register. And I would observe that I like lingering sunsets. I would really like to spend some time by the lake with a lingering sunset. Thank you, Mr. Thompson.
Any other questions, committee? Okay, thank you so much. All right, I will close the hearing on HB 2166. Okay, we now will hear HB 2134. We'll hear again from Jason. Committee, I'm going to take this minute right now to just explain. So we have two hearings. As you can see in your agenda, we have quite a few written onlys, but we have a lot of people that are going to be here speaking too. We're going to do 2 questions for everyone, and that includes a follow-up question. So if you have a question and a follow-up, that's it. Unless we have time at the end, I will be happy to call on you again, but we're going to stick to that, and we need to establish some good habits because next week we are going to be really pushed and have a lot of hearings. So we're starting that today. And so we'll just begin HB 2134. Jason, go ahead and give us a memo, your brief on that. Thank you.
All right. Thank you again, Madam Chair. Jason Thompson, Revisor's Office. This is House Bill 2134, amends Kansas Open Records Act regarding charges for records in the state executive branch and other public agencies other than the legislative and judicial branches. It prohibits charges for electronic copies of records and for determining whether a record exists, and it limits charges for employee time required to make records available. I'll try to keep this short. I know you got a lot of folks that know some of this better than I do, so I'm going to get out of their way. The amendment is to Section 1, KSA 45-219. This is the statute in the Open Records Act related to obtaining copies of public records. You'll see on the bottom of page 1, subsection C of current law, talks about public agencies prescribing reasonable fees for providing access to or furnishing copies of public records. The new provision that the bill adds is on page 2, beginning about line 12. There's a subsection or a paragraph that provides fees for access to or copies of records of a public agency not described in paragraph 3 or 4. So that would be 3 is legislative branch, 4 is judicial branch. So for non-legislative branch, non-judicial branch agencies, fees shall be established by the agency head as follows. First, for printed copies of public records, a fee equal to 25 cents per page, and no fee is charged for electronic copies, or the cost of the employee time required to provide access to or furnish copies of the records, which shall not exceed the lowest hourly rate of an employee qualified to provide the requested records, plus the actual cost of printing copies. And again, no fee for electronic copies. So that's the key provision there, and on page 2, that would be a change. Additionally, you will see in subsection D of current law, beginning in line 22 of page 2, that a person requesting records may appeal the reasonableness of the fees charged for providing access to or furnishing copies of records. So we modify that provision to say a person requesting records within the executive branch appeals to the Secretary of Administration, and their decision is final. And then new D2, a person requesting from a political or taxing subdivision appeals to the governing body of that political or taxing subdivision, and their decision is final. So that's the provision there on page 2 that's also new. I think that's it. It would take effect on July 1st, 2025 if enacted, and I'll be happy to answer questions.
Okay, thank you. And can you give us a little history on, I mean, I know we had a similar bill and the proponents and opponents can speak to this too, but is it very similar or were there some changes from last time?
So, Madam Chair, I did not draft this one myself, but in reviewing it with the person who did, it is a little different than the bill heard by, I believe it was Fed and State last year that heard a bill on this. Maybe it was you. There were a couple provisions in that bill that are not in this bill. A lot of the fee structure is similar. I think this language has been floating around for a while in various iterations. But I think this one might be a little narrower than some of the past ones. But yeah, hopefully the conferees can kind of speak to that a little more.
Okay, committee, any other questions? Representative Carmichael.
Thank you, Madam Chair, and I will hold it to 2.
Just make it 1 for me.
Yes, I'll make it 1 for you, Mr. Thompson, out of professional courtesy. In the neutral testimony, I believe, of the Attorney General's office, they posed the question as to whether or not this legislation would supersede or modify the review by the attorney, or the appeal, if you will, a review by the Attorney General's office, and substitute review by Secretary of Administration, et cetera, or whether both appellate or review tracks would still be in effect, if you know. And I just saw this myself momentarily, so I may be in the blue. Or, never mind, that's my question, Madam Chair. My one question, Madam Chair.
Thank you. Jason?
Madam Chair, Representative, I think it's an interesting point, and obviously the Attorney General is in charge of enforcing CORA and COMA, as we talked about on the first day of committee. I will point out the current law is that furnishing copies, you appeal that to the Secretary of Administration, their decision is final. That's current law. The specificity here is that it's executive branch decisions that go to the Secretary of Administration, and they are only dealing with the reasonableness of the fees charged. So it's a fairly discrete ruling that they make. So any sort of conflict, one, already exists now, right, between the two potential reviews. But two, if there is a potential conflict, we are adding to that by saying agency or political or taxing subdivisions and their bodies are going to now make those decisions about reasonableness. So we may have compounded the problem if there is one currently. So I'll have to defer to the AG about whether there's a problem now, because it is current law. And if it is, this would seem to compound that by making it another group of folks that are making a final decision. And how does the AG deal with that when they're enforcing all the issues? But reasonableness of fees is one particular issue I believe they also enforce. So as the enforcers, I think they raise a valid point. I don't know that this resolves it. Maybe I should just say that.
Thank you, Mr. Thompson. Thank you, Madam Chair.
Representative Schreiber.
Thank you, Madam Chair, and thank you, Jason. I have a hypothetical for you, and just wondering how this change might affect that or not affect it. If someone had to scan a lot of records and then transmit them electronically, would that phrase on there about no such fee shall be charged for electronic copies would not apply to the scanning process, or what? I'm just, like I say, it's hypothetical.
Madam Chair, Representative, that's an interesting hypothetical. I could see you arguing either way if you're on either end of that. Well, I could see one interpretation. You've put me in the position of where I always am, right? I'm in the middle here. I'm trying to be neutral. I'm just trying to tell you what the language says, right? So the idea is staff time for providing the request, that you can charge for that, right? So if there's staff time involved to make them electronic records, and I'm the agency providing it, I'm going to say you should pay. But if I'm the person who has to pay, I might say, no, those are electronic copies, I don't have to pay you. I don't know that I can resolve that, but I can tell you that's kind of the push and pull provided by this language, so.
And that's fine. I just wanted to check and see what the clarity is on that. Thank you. Thank you, Madam Chair.
Representative Barth.
Thank you, Madam Chair. Thank you, Jason. This has actually been an issue that I've had some constituents bring forth to me, is just getting the data and the cost for the data and access to the data, who are really for government transparency. And I know that there's a hearing, I think it's today, or as well in the Senate, SB 70, which to me, I just looked it up, it's a different bill sponsor. I don't know if you have much information on it. I just glanced real quick and it looks like the fee amount is less, which is of interest. But I also think if there's any other data points that you can point out, I don't know if you wrote the bill, how much you know about it, but if you could highlight those, that would be great. Thank you.
Madam Chair, Representative, I didn't write the bill, this one either. And I'm aware of it only because I was listening to the Senate Judiciary Committee this morning. Again, with a room full of people, a lot of the same folks, honestly, I think. So you might hear a little bit more about how that bill differs or what they like. But yes, the fee in that one is slightly lower. I think it was maybe 12 cents in some cases. There are a few other differences I can't remember for sure. But yeah, the Senate did have a hearing on that issue this morning. And a lot of the folks in the room could probably tell you more about that bill and whether they like it more or less than this one. But yeah, it is different.
Okay, committee, any other questions for the revisor? Representative Osman.
Thank you, Madam Chairwoman. Not necessarily directed to you, but housekeeping question. Is there a fiscal note attached to this?
There is a fiscal note. Did you get it in your? It's in the S drive, and then it's also.
It is, yes, thank you.
Okay, thank you. All right. We will go ahead and hear from the proponents now. I'll call Dave Trobert from the Kansas Policy Institute. Welcome to committee.
Oh, sorry about that. In support of the, do I need to start over with the, okay. My name's Dave Trobert. I'm CEO of Kansas Policy Institute, and we're pleased to be here in support of HB 2134. Let me start by saying I am not an attorney. I'm just a recovering accountant. So I'm not giving legal advice. But I would say a common sense reading of the current law that says shall not exceed the actual cost of fulfilling the requests is key here. What we see happening is, it's happened to us a lot. We get charged 25 cents a page plus employee time. It never costs 25 cents per page to print anything. Now the cost is somewhere between a nickel and 8 cents. So it seems that perhaps the legislative intent of 25 cents was that that would cover employee time and the cost of printing a document. What we're getting now is employee time plus the cost of the document, or in the case of electronic records, various fees plus employee time. The intent of this bill, which is similar to what we proposed last year, is that you can either charge 25 cents per page and no employee time, or you can charge employee time and the actual cost of printing a page. With the case of electronic, it would be the same thing. You can charge, it was 12.5 cents, I believe, in the Senate bill this morning. You could charge that. There's no cost of attaching a document, and that's the intent of this, is the actual provision of the document, not the time it took to gather it. But you could charge the actual employee time for gathering records that are being provided electronically. But you can't charge for simply attaching a 100-page document, because it didn't cost anything. The cost of your email did not increase because you attached an electronic file. The one other intent is that we have in law that you cannot charge more than the hourly rate of the lowest capable employee of performing that. And finally, in looking at some of the testimony, I want to clarify that this is intended to apply to all units of government, state and local, not just executive branch. So if there's any amendments that need to be made in those regards, I'd be happy to work with the reviser accordingly. I've included several examples of how the law we think is not being followed at this point. For example, USD 257 IOLA has on their website, they charge $1 a page. They charge a flat fee for corporate. That's not what the current law says. We get a lot of these variations all the time. And we're simply trying to put something in here that really lives up to the shall not exceed the actual costs. And with that, I'll be happy to stand for questions.
Okay, thank you, committee. Do you have any questions for Mr. Trobert? Representative Carmichael?
Thank you, Madam Chair. First, Mr. Trobert, I apologize. I have called you Trabert for the last 12 years. I will try to do better. I'm sorry.
Thank you. That's quite all right. That's one of the nicer things I've gotten called in this building.
Probably especially by me. I do have two substantive questions. First, as I inquired of Mr. Thompson and as the Attorney General's testimony suggests, there may be either a conflict or a misunderstanding, if you will, about whether the Attorney General still reviews for noncompliance upon request, or whether the appeals to the administrative agency, if you will, are final. KPI was with folks who offered this, or it was offered on behalf of KPI. So what is y'all's intent? How do you want it? Do you want 2 levels of review, 1 level of review? Can you help me with that?
Actually, I really can't answer that question, Representative, because the information, and it may have been lost in translation somewhere, we did not convey, or I did not convey, a desire to change the review process in what got to the revisor's office. That's probably some miscommunication between us and Mr. O'Neill and how it got there. That we are not trying to change it.
Madam Chair, if there's something needs to be clarified, I'm certainly happy, and I'm sure many of the rest of us are, to work with Mr. O'Neill or Mr. Trobert, whatever's necessary to get what they want. And that's all the questions I have. Thank you.
Any other questions, committee, for Mr. Trobert? Okay, Representative Barth.
Thank you, Madam Chair, and thanks. The other issue, in addition to cost and the transparency piece of it, is the length of time that it takes from the time you make the request of what documents you're wanting to the time that you get it. So can you tell me if you have that same concern and how you're hoping that's addressed through here as well? Thanks.
Certainly, Representative. We've had, it varies. In some cases, we've had some, I would say that under both the Kelly administration and the previous administration, the state has been really good about information we request from, say, the Department of Revenue, the Department of Education. The challenges we face are almost exclusively with local units of government, school districts, cities, counties, and so forth. In some cases, the information does come back what we would consider to be promptly. In other cases, it can be delayed weeks or months. Sometimes that's because, and I'll give you one of the most bizarre examples, a request for something that we had previously received from a school district was handed over to an outside attorney to review and argue with us for a couple, maybe 3 weeks, over whether we were really entitled to get, we were asking for a list of employees and their pay rates, and argued over whether we should be allowed to get it in electronic format. So they ended up spending a lot more money probably on that attorney, because we did get what we wanted, and they ended up charging us a relatively small amount, because they charged the fair amount, not for the attorney, but we see it from one end of the spectrum to the other. There can be some serious delays. One common thing that happens is we're too busy. And everybody's busy, but the law doesn't say that you provide the records when you have time. And so if there was anything that you'd like to see to tighten that up, we'd be happy to work with you on that.
Committee, any other questions? Okay, thank you, Mr. Trobert, for being here. Committee, we have written only proponent testimony from Emily Bradbury from the Kansas Press Association, Allison Mazee from the Kansas Association of Broadcasters, and Brett Anderson, private citizen. Please take a look at those. That would either be in your packet or on the S drive. Okay, we will now have opponent testimony. We have a number of opponents. I'm going to ask you to limit your testimony to 2 to 3 minutes. After 3, we'll give you a warning, but I don't want to be too strict about it, but there's a lot of you may be saying some of the same things, so try to keep it within the 2 to 3 minute range. And I will first call on a friend of the Judiciary Committee, Amanda Stanley. Welcome to committee.
Thank you so much, Jay, for allowing me to testify today. I am Amanda Stanley, City Attorney for Topeka, so I get to live and breathe open records on a daily basis. So we do have concerns with this bill, and I think what I would like to convey mainly is the scale of this when you're talking about the city the size of Topeka. So we get over 7,000 record requests a year, and that is conservative. Our actual numbers like 7,332 from last year, so we do track those. Even assuming that we only spent 5 minutes on each of those, that's over 600 hours of staff time just processing record requests. And so when you have a scale of records that much, there does have to be some reasonableness with recovering your costs of that, as well as the time it takes to fill them. At the City of Topeka, we try to work really closely with record requesters when they have very broad requests. We engage in that interactive communication to say, do you really want every email that says elephant? And I use this example all the time, and it sounds crazy, but we did own a zoo and we had a record request for an elephant autopsy. And there are a whole lot of emails that include elephant feed and everything else when you buy an elephant. Is that really what you want? And trying to narrow it down. Having the ability to charge and recover staff time gives you some leverage to actually negotiate to get to the root of what the records are so that's efficient for everyone. We get so many requests that come from a wide variety of sources, in-state and out-of-state, and we already deeply discount our staff time at the City of Topeka. It's $35 an hour for an attorney rate there, which is a discounted rate that does not cover all our costs. And our governing body does that as a policy reason to try to encourage transparency and get those requests out. But to be able to have completely free requests to those staff times to recover those hours gives no incentive to actually work together and try to come up with a cooperative way to figure out those requests. It is not uncommon for me, unfortunately, to get requests for so many emails that it would be on average 190 hours if we went with their initial request of staff time just to gather those kind of records, redact them, figure out which ones are attorney-client privilege, which ones are responsive. So we do need to be able to engage in interactive communication. And I do think our local taxpayers do have some expectation that we aren't completely subsidizing all of these records requests. That if you want unlimited information, it should come at a cost-benefit analysis here, that you should have to put something in as well as you're getting that information. Not because we don't believe in transparency, but because everything has a cost. And ultimately, if we're paying for that with staff time, we're paying for that with property tax dollars. So it all comes with an offset. So for that, we'd ask for some clarity in the bill. We would like to maintain our ability to charge for staff time and have you carefully weigh the unintended consequences. I do agree with the Attorney General's analysis on that piece. I do think by taking appeals to the governing body, it probably takes authority away from him, at least as a good lawyer. That's what I'd argue. So I would probably suggest that appeals to the governing body is not the best way to go about it, and that we already have a current system. If you have things like the Iola testimony, you can report those to the AG now and have him investigate whether or not that is a current way to do that. So with that, I'm happy to stand for questions.
Okay, I think we'll do all the questions at the end. Yep, thank you. You were right on 3 minutes. Way to go. Okay, Angela Stahlbaumer from the Kansas Association of School Boards. If I said your name wrong, just go ahead and correct me.
You did great. Thank you very much. My name is Angela Stahlbaumer from the Kansas Association of School Boards. So thank you, Chair Humphreys and members of the committee. I don't want to belabor necessarily what all of our school boards have asked us to lobby for here at the Capitol. What I will fall back on is that they really want to be able to at least recoup their actual costs for providing copies of records. And with that in mind, we do show up here today in opposition of this bill. I would call your attention to Section 1 of the bill specifically. So this would amend KSA 45-219. If you focus on subsection C5, so one of the things that we do have our members on board with is the idea that public school boards should not be treated any differently than other units of government. And in this case, the executive branch, public school boards, cities, counties would have different rules than would other, legislative bodies, judicial bodies. And so that's one issue that we have with it. But if you look at the language specifically, certainly the language in subsection A talks about how the fee should not exceed 25 cents per copy of printed copies, but says for electronic copies, there is no charge. But focus on subsection B there. So it says for the cost of employee time required to provide access to or furnish copies of public records a fee that shall not exceed the lowest hourly rate of an employee qualified to provide the requested records plus the actual cost of printing copies of public records. But then it says no such fee shall be charged for electronic copies. So if you look back at that first sentence, it's not abundantly clear that it's saying you just can't charge for copies. It leaves it open that there is a fee established for staff time as well. And so we would ask for clarification that districts and other bodies still be able to recoup the costs of staff time, because the fact that we provide these records electronically does not cut out all of the review, redaction, and all of those things that the other conferees have talked about. And so then similarly, Section 1, subsection D2 of the bill allows any person requesting records to appeal that. In our case, that would go to boards of education. We would mirror what the city of Topeka just said, essentially that the number of requests that districts receive for core requests are a lot every school year. So we feel like an appeal to the board directly on each and every one of those could be somewhat burdensome when there's already a process to go directly to the records custodian. I happily stand for any questions. Thank you for your time.
Okay, thank you so much. Also great with the time. Okay, Jay Hall from the Kansas Association of Counties. Jay, are you here? Yes? No? Okay, is he gone for good or, sorry? Okay. Okay, then he will be written only. Please take a look at his testimony. John Goodyear from League of Kansas Municipalities. Welcome, John.
Thank you, Madam Chair, members of the committee. Good afternoon, and thank you for having me today. My name is John Goodyear, and I serve as General Counsel for the League of Kansas Municipalities. Our testimony echoes the prior conferees. We support the continued ability of local governments to be able to assess those reasonable fees that are associated with the furnishing of public records, to include the costs that are associated with the review and redaction of certain records. There are real costs associated with these, and doing away with the ability to recoup those costs shifts that burden. Those costs don't go away, they're still there. It just shifts the burden on who's paying them. It's the position of the league, and it's been the position of the legislation of the Open Records Act that duty should be borne by the requester. Since 1984, there's been an ability to collect from the requester the actual costs of furnishing records, to include those fees, those costs associated with record review and redaction. You've heard numbers in the thousands. Many of our cities deal with records requests in the hundreds. We have some that deal with requests in the thousands, and they have to respond to all of those. There's a duty to respond to all of those. That takes time. Many of these requests are easy to fulfill, and cities will waive any fees or won't assess any fees for those. So what we're talking about here are the significant reviews. That's where the impact of this legislation will be felt. Cities are advised to work with requesters to limit costs. Sometimes a request as written, as it comes to a public agency, will yield 15,000 records. And that's not uncommon. If you're asking for every email that mentions the word elephant or every email that mentions the word water, that could result in 15,000 documents. So cities are advised to work with the requester to narrow that request down. That's going to help you limit your costs and limit the staff time that's associated with filling that record. We work with requesters to ensure that those costs are lowered, but there are legitimate needs for actual significant review to make sure that we're getting every document that they need, that they've requested, and to make sure that every bit of information that needs to be excluded from the record, there are legitimate reasons for redacting information, reasons that were required by law to redact information, make sure that all of that's covered. And that sometimes requires significant staff time. As a final point, I think we're almost all in agreement on the administrative process that's created by this bill, allowing or requiring governing bodies to take a look at whether or not fees are reasonable. I would just point out that we have a current process in law. The Attorney General's office, county and district attorneys have concurrent jurisdiction to look at violations of the Open Records Act. That includes reasonableness of fees. In fact, I took a look at the 2023 and 2022 reports that were released by the Attorney General's office in preparation for this hearing, just to see how many times they fielded complaints regarding reasonableness of fees. In 2023, there were 4 complaints that mentioned reasonableness of fees. One of those was referred to the county attorney. Yes. And one of them was for a bank, so not even an entity that was covered by the Open Records Act. So that just highlights that there is a process in place. People are filing complaints, although very limited. And Madam Chair, I'll wrap it up and I will answer questions at the appropriate time.
Okay, thank you.
Thank you.
Okay, Michael Koss from the City of Overland Park. Welcome to committee.
Madam Chair, I'm also joined by the captain who leads our records division in our police department. Our police department handles 80% of our open records requests, so I wanted him to be available to answer any questions about the adverse impact they have on the department. Just echoing what the opponents said about these requests having costs, I just want to drive home the point that if you take away a municipality's ability to reimburse itself with fees for requests, those have to be paid another way, and that is increasing taxes, increasing FTEs to provide that government service. And I think a good way to illustrate that is to take an example that we received, which was we got a request for a specific name, and that yielded 30,000 matches in our email system. And what we told that requester was, well, this will take a year. It will cost you this many $1,000s. And then we had an interaction with them. Said, okay, maybe you're only interested in that name from this department. Maybe you're only interested in this time frame. And we worked together to come to a consensus about what was the information they were actually looking for in a way that was a manageable cost to them and the taxpayer. Now you live in a world where this becomes law. And that requester says, okay, it's going to take you a year, but it's not going to cost me anything. That sounds like a you problem. I'll calendar this and I'll come back. And that person was able to commandeer our staff to just go to work. And if every resident or any citizen can come in and say, I want you to go on a 6-month search for this word, and there's no sort of interaction requiring a narrowing of that search, that's going to be an enormous unfunded mandate on municipalities across the state. With that, I'm happy to answer questions at the appropriate time.
Okay, thank you. Yep, we'll do them all at the end. Okay, now we have Sheriff Jeff Easter, who is going to come by WebEx. He's not feeling well today. Mr. Klump, would you like to say anything instead of Sheriff Easter? We're sorry that he's not well, but I think you're kind of his go-to guy.
Thank you, Madam Chair. I will mention a few things that's in our testimony that hasn't been spoken about yet. My name is Ed Klump. I'm not Sheriff Easter, and I'm thankful I'm not today because he's ill. And I'm here representing 3 associations. I usually do the Sheriff's Association, Chiefs Association, the Peace Officers Association. Well, not the peace officers, I'm sorry, just the chiefs and the sheriffs today. And one of the things that law enforcement is confronted with is different types of items that are being requested, such as photographs and video. And it's not always our body cam video or vehicle video. Sometimes people come in and they want crime scene video. They want video of something we took maybe now with drones or whatever. And there's a great deal of redaction has to be made with that. Many of our small agencies don't have the software or the technology to do those redactions, and they have to contract that out. So I think one of the things you need to consider in the real costs is when we have to contract work out, that needs to be covered somehow. There's also a huge difference in different levels of people that have to be involved in some things. Like we can have a low-level records clerk, not at a very high salary, go pull the documents, but then you need somebody at a higher level that looks at those to determine what needs redacted or what is protected in some of the exemptions and things like that. And then many of our cities, we want legal staff to review it at the end and make sure we're complying with the law and that we're not putting something in there that we shouldn't be putting in there. And those all have different salary rates, and in the bill, in the statute, really aren't very clear in how that works. I think it probably covers it, but it's just not very clear. There's been a lot of things said about clarity, and I think that's part of the issue here we all have is how those variations all get taken care of. And I think most everything else that we have in our testimony has been talked about, except for one thing, and that is when we give electronic copies, sometimes we can do them by email, as been mentioned, but that's not always the case. Sometimes the volume is so big, they're impractical to email them. So we need to put them on an electronic medium, and we don't want to use their device on our equipment. That's a security risk. And so what we typically find is we charge people for a device like a thumb drive that's big enough to hold the data that they're requesting, and that cost can vary, and that needs to be recoverable as well. So those are just some of our thoughts on it, and I'll stand for questions at the appropriate time.
Thank you for standing in. Okay, and the last opponent, Paul Kramer from the city of Shawnee. Are you here? Okay, so I think Paul Kramer will be written only. Yep, he does have a page in here. So. Okay, committee, we will go ahead and see if anyone has any questions or any of the opponents. Do I have any takers? Representative Carmichael.
Thank you, Madam Chair. A question or two for Sheriff Easter's alter ego, Chief Clump. As you're approaching, Chief, I want you to know I promised a member of the Sheriff's command staff that I would give the Sheriff a hard time today, and I guess I'll have to take advantage of you instead.
So I'm going to get a hard time by proxy?
I do hope the Sheriff gets better soon. You did mention this matter of media, sticks, thumb drives, etc. I mean, you can get an 8 gigabyte thumb drive for, I don't know, $5 now, less than that. Are you saying that as the Sheriff's Association, etc., interprets this, you would no longer be able to charge for those thumb drives or other media, whereas presently you are able to charge?
Well, it's one of the expenses we have, right? And we just want to make sure it continues to be covered. I don't know if it's really covered that clear because now we talk about cost per page. We don't talk about cost of delivering the electronic. And when we have this bill that says no charge for electronic documents, does that mean we can still charge for those kind of things? Or does it exclude it? And we're just asking for clarity.
Madam Chair, I think you may raise a good point, but if they want to prepare a balloon or help or whatever, I know the door's open, and I hope we can accommodate that. And I'll save my other questions for when the Sheriff is feeling better. Thank you.
Okay, committee, any other questions? Representative Schreiber.
Thank you, Madam Chair. Don't go far, Ed. So my hypothetical that I asked Jason, how would you view that, excuse me, if you had to scan a lot of documents and email them to somebody, would you count the scanning as electronic copying or?
You know, it's been a while since I've been the person directly involved in any of this. I'm not sure what the practice is now. I would think if it's not already an electronic document, we would probably make photocopies and charge them under the photocopy provision, but I may be totally wrong with what the practice is today, so I'm just not positive of that answer.
Okay, committee. So I do have one question for Amanda. I'm curious if you think there is a compromise in this bill. You know, everyone has kind of said clarity would be better. Do you feel like that's a possibility here?
I've come back like 3 years in a row and testified on this bill. And the thing that I keep hearing is it seems like there's a lack of interactive communication. I would add language that requires the entity to interact with the requester when they make these big requests, to rather than just give a cost and say, hey, it's going to be X amount, to have that dialogue. We do it voluntarily. It's not in statute. You don't have to. I noticed the importance of it when I was in the ICU, actually, because our media reached out to me and said, why did this process take so long and wasn't as easy? And I was like, well, because nobody was there to do the interactive communication. So I would write that in, and maybe that would solve some of these problems.
It's interesting, and I do think after all of these years, not in this room, not these proponents and opponents, but there's bad actors on both sides. People ask you for unreasonable things, and then there are entities that unreasonably charge. So, you know, if we could come together, it sure would be great. So maybe we'll try and work on that.
Okay.
Yep. Okay. Thank you so much. Committee, we have written only opponent testimony from Nick Gregory from the city of Mays, Danielle Doolin from the city of Manhattan, Wendy Green from Wyandotte County, and Kansas City, Kansas. And then we also have neutral written only testimony from Matt Bengesser from the Office of the Attorney General. So please take a look at those and know that you know, this is a bill that we've had before, and we'll try to, maybe we can come to some sort of resolution this year on this bill. We'll try. Okay, I will close the hearing on House Bill 2134, and I'll open the hearing on HCR 5008 and ask Jason for a brief, please. Thank you.
Thank you again, Madam Chair. Jason Thompson, Revisor's Office. Another thing that might seem familiar, so we'll dive right in. HCR 5008 proposes a constitutional amendment to provide for legislative oversight of rules and regulations adopted by executive branch agencies and officials. The proposed resolution would enact a new Section 31 to Article 2 of the Constitution, which is the legislative article. This new provision would say that the legislature can provide by law to approve proposed rules and regulations and proposed amendments to existing rules and regulations prior to their becoming effective. Further, the legislature would be allowed to revoke or suspend any rules and regulations or portions thereof by adoption of a concurrent resolution if the legislature finds that the rules and regulations are or meet one of the 9 criteria listed in the amendment. I won't go through all those, but they range from being obsolete to being not beneficial to the public good in the sole discretion of the legislature, is how that one's phrased. Just to give you a very high-level background for those of you that are new, the current rules and regs process, and I caution that I only backed up on rules and regs for a couple of years. It's not my committee, but you have a good resource here in the chair and another chair that can fill you in on this a little bit. There are statutes that say essentially that the Joint Committee on Administrative Rules and Regulations reviews all proposed rules and regulations during the public comment period, right? So there's a whole process that goes on at the agency level, the AG review, and then there's a public comment period as well. And the legislature looks at this with its committee, and after they meet and question the agency about the rules and regulations, they issue a report to the legislature. And essentially it's got comments and concerns with the proposed rules and regulations. The committee can introduce legislation in response. So if they don't like something that's proposed, they could propose a bill that does the opposite, for example. And that's the way the legislature can interact with rules and regs. But the committee cannot require changes to the rules and regs that are put in front of them, and the committee cannot reject those rules and regulations. And the reason for that, not to get too deep into it, but just because I know a couple of the members have a background in this, there's case law from the federal level that filtered down to the state level that essentially said the legislature can't veto rules and regulations. You gave the executive branch the power to enact the rules and regulations. When they come back to you, you can't just veto them. If you want to override them or enact the opposite, you have to enact a bill and present it to the governor and either override a veto or have the governor sign it. So it's the enactment clause that sort of became the hurdle to being able to just veto rules and regs, which was a practice for many, many years in many state legislatures, including this one. So that's a very high level background of kind of how we got there. We could veto in the past, the legislature could veto in the past. That was overruled and not allowed. And now you're left with this committee that just reviews, sort of advises and gives recommendations on rules and regs. So this enactment by amending the Constitution, if the people were to adopt the amendment, would sort of bypass the enactment clause and say the legislature constitutionally has the authority to deal with proposed rules and regulations in a way that they can't now. So that's sort of the very big picture of where this is and what it would do. I would mention that if enacted by 2/3 majority in both chambers, which is what's required, it's presented then to the electors, which is the general population of voters, and it would be held, it would be on the ballot at a special election called on August 4th of 2026, which would be held in conjunction with the primary election that's held on that date. So those are kind of the magical constitutional words to get that on the right ballot, August of 2026. And I already know preemptively there's a question about how this relates to the ballot question that was enacted in 2022. So I'm ready to address that if you'd like, Madam Chair, or just answer any other questions you might have.
Thank you. So the question that was in the general election of 2022, that's what you're referring to? The similar one? Okay, so go ahead and tell us similar, different, how does that relate?
Yeah, so Madam Chair, in 2022, some of you may recall, the House concurrent resolution was 5014-5014. It was enacted by 2/3 majorities in both chambers. It did appear on the ballot, and it was a very close vote against was what prevailed. I have the Secretary of State's tally here. It looks like it's about 480,000 plus to about 472,000 plus in favor. So close margin, but 50% to 49%, the language was defeated at the ballot. I didn't do a very specific comparison, but the resolution language that was there last time was one paragraph. It just simply said, whenever the legislature by law has authorized any officer or agency within the executive branch to adopt rules and regulations that have the force and effect of law, the legislature may provide by law for the revocation or suspension of any such rule and regulation or portion thereof upon a vote of a majority of the members then elected or appointed and qualified in each house. So if I remember right, the reading of that was that the legislature would enact statutes to implement that constitutional language, and the legislature would be able to revoke or suspend rules and regulations simply by voting amongst yourselves with no presentment requirement to the governor. So a little different than the proposal here, which says the legislature can just do all of these actions provided in the HCR, and they could do them by concurrent resolution, which also does not require presentment. So a similar change in law, but a different approach, and a little bit more in this provision than in the last provision. So it wouldn't be left to legislative enactment later. Some of it would be in the Constitution. That's kind of my high-level overview of the differences, but the conferees might have some details for you.
And so the language that we see here, that would be printed on the ballot?
Correct.
Pretty much all of the 9 criteria and so on?
Right, so typically when we see the ballot, when we're voting, it has the proposed addition to the Constitution plus those explanatory statements that we helped write that say what a vote for and a vote against this proposition would mean. So yeah, all of this would appear on the ballot.
Okay, committee, do you have any other questions? Representative Goddard.
Thank you, Madam Chair, and thank you for your briefing. As I read this thing, the real action part of it is if the legislature would not approve of a rule or regulation, but if they are mum on the subject, then there's really nothing that's going to be done with the rule and regulation. They don't have to adopt it. Is that correct?
Madam Chair and Representative, yes, I think I think the point is for it to be very similar to what happens now. Nothing changes in the Rules and Regulations Filing Act. Nothing changes in the process of how you promulgate, to use the law term, rules and regulations. They would still go through the normal process, but the change would be the legislature would then be allowed to revoke or suspend rules and regulations by concurrent resolution. So if one of them comes before you, you could say it's revoked, it's suspended, and you could also provide by law to approve them and even propose amendments to existing rules. That gives you the option to enact laws that would change the process, but it doesn't require it. So if that makes sense, right? So it's kind of two provisions. Subsection A of the new language says, you, the legislature, can provide by law that you want to approve regulations or you want to amend proposed regulations prior to them become effective. But to do that, you would have to enact a law, which means you present it to the governor and override a veto potentially. The other option is once they are in effect, you can revoke or suspend by using concurrent resolutions. So it's kind of a
Which
two-pronged.
still requires a 2/3 vote of each body.
So concurrent resolutions, I think, are just majority votes by both bodies. The constitutional concurrent resolutions
I see.
require 2/3
Okay,
votes, but
okay.
a regular concurrent resolution.
Okay, thank you for that clarification.
Thank you, Madam Chair.
You're welcome. Representative Schreiber.
Thank you, Madam Chair, and thanks again, Jason. You mentioned about the promulgation process for regulations. If the legislature revokes or suspends a particular regulation that's presented to them in rules and regs, does that regulation then have to go back through the process through the Department of Administration and the AG and so forth?
Madam Chair and Representative, because it would be provided by law, we don't know necessarily, but if you got to that point and the legislature said no, I think your only option would be to start over, right? Just logically, but there may be a mechanism the legislature could create in the law that maybe they just revise it a little bit and they don't have to start all the way over. But subsection A, because it's in the Constitution, and we do this in a lot of places, we just give the option for the legislature to provide the details in law later. But giving you the authority and the constitutional ability to do it is what the subsection gives. And then the details would be worked out later. And that's obviously an important detail you'd have to provide, yeah.
Representative Osman.
Actually, Senator Goddard and Mr. Thompson covered the question that I had, at least at that moment. Thank you, though.
Great. Okay, Representative Osman.
All right, thank you, Madam Chairwoman. Thank you for your explanation. So under this HCR, is there a specific window in which the legislature must act, or is there a specific look back period that you have in which the legislature is bound by?
Madam Chair, Representative, I think the short answer is no. There's not any specificity about window or time. It's just one provision is before, they're proposed. The other provision is revoke or suspend. Could happen at any point after. So.
Okay, thank you. One other question, if I can. On page 2, line 4, so subsection 9, it says, in the sole discretion of the legislature, not beneficial to the public good. Does that mean that under this wording, there is no ability for judicial review or any other review? It is solely the legislature's purview?
Madam Chair, Representative, so I saw that language too. I don't know that I can speak for the proponents, but I believe that might be the attempt with that language to just make it clear that this is the legislature and their sole discretion to decide this is not beneficial to the public good, and for that reason, we're enacting a concurrent resolution to either revoke or suspend this rule and regulation. And so the idea, I think, is that you couldn't challenge that basis. You might be able to challenge in some other way, but I don't know that without some wrangling, the legislature is hoping to say it's our sole discretion that this is not in public good, and that underlying finding can't be challenged. Whether that actually can work out in the legal system is a question to be determined, of course.
A lot to be determined. Thank you very much.
Okay, thank you, Jason. We appreciate it. Yep. Okay, committee, there are actually 4 proponents. We had one added this afternoon or this morning. And I'm going to go ahead and call Representative Wassinger up. And so, Representative, if you can, after, make sure we get your written testimony, that would be great.
Yes.
I don't think we have it in our.
No, you don't. But thank you, Madam Chair. Bureaucracy was set up as a rational way for government and for businesses to organize. It made sense. The problem with bureaucracy is that rules and regulations have become a way to pass things with the weight meant for laws without going through the legislature. And I'll give you a good example. The Department of Labor came in front of our committee and brought 6 regulations which clearly changed workman's comp law. And I said to them, I'm sure this is probably necessary. You should go through the Judiciary Committee so that you know that someone will know that it's law, not just jammed into rules and regulations somewhere that nobody can find. So they went ahead and said, we don't care. We're going to do this. We're just going to do it by rules and regs. I had called the Attorney General's office and asked them to re-look into these rules and regs that they were doing, and they found 3 of them did not meet constitutional muster. So it was correct that they were trying to pass laws by regulation. It won't happen very often. Honestly, most rules and regs we leave up to the agencies and organizations that do this every day. I had one legislator say, so you're going to tell people, you're going to tell the Department of Transportation how to build a road. Absolutely not. But when things are affecting the laws in our state, they are legislating by regulation, and it's not right. And it's really the job of the legislature to do that. With that, Madam Chair, I'll stand for questions at the appropriate time. Thank you.
Great. Thank you. We will ask questions at the end, if that's okay. Yep. Okay, I'll now, we have James Manley from the Pacific Legal Foundation on WebEx. Hi, Mr. Manley, are you there? Thank you for waiting.
My pleasure. Thank you, Madam Chair.
We, we're going to work for about 3 minutes, each one about 3 minutes, if that suits you okay. So that's what we'll
Thank you
shoot
very
for.
much.
Okay, thank you for waiting. Mm-hmm.
Yes, I will try to be very brief. I think the reviser did a fine job of explaining the resolution. I just want to emphasize a few points. First of all, what the Kansas legislature last session, and I'm sorry, let me introduce myself. I'm James Manley. I'm the state policy chief for Pacific Legal Foundation. PLF is a national nonprofit law firm. We've worked on this issue of legislative review of rules in many states. We were engaged last session when the Kansas legislature took the important step of enacting HB 2648, which addresses that pre-review of proposed rules, particularly rules that have a significant economic impact. All this amendment does, in my view, is change that secondary review when the legislature reviews rules that have already gone into effect. And I think it's the other side of the coin to what the legislature did with 2648 last session. It just ensures that there is legislative and democratic accountability for rulemaking when agencies are in adopting rules subject to older statutes, when agencies are reinterpreting existing rules or amending existing rules, to ensure that the agencies are using the authority that the legislature has delegated to them, and only that authority. And that democratic check on the rulemaking process is exactly what motivated the legislature to pass 2648 last session. And I think the same justifications apply here to give the legislature the ability to put a check on administrative rulemaking and ensure that the agencies are only using that power that the legislature has given them. I'm happy to answer any questions, but I will leave it at that. Thank you, Madam Chairman.
Okay, thank you. We may have some questions after a couple more proponent testimony. Thank you. All right, Tanner Temple from Americans for Prosperity, come up. Welcome to committee. Yeah, make sure that's on.
Try that again. Madam Chair, members of the committee, my name is Tanner Temple, Deputy Director for Americans for Prosperity. Thank you for the opportunity to support HCR 5008, which aims to add a rule to the state constitution requiring the legislator to review new regulations before they take effect. Unelected agencies currently have too much power to create and enforce laws without legislative input. Kansas has over 70,000 regulations, which are costly and complex for businesses and individuals. These regulations total 3.2 million words and take a substantial amount of time to read. The growing number of regulations increases prices, stifles entrepreneurship, and discourages job creation. This legislation aims to reduce those regulations, lower costs, and ensure elected officials oversee regulations. Kansas is one of the 16 states without permanent legislative review process for new regulations. This lack of oversight has contributed to economic stagnation and job losses. Kansas recently lost roughly 1,200 jobs and ranks outside the top 20 states for business climate. States like Idaho, Arizona, and Virginia have cut regulations and seen strong economic growth. HCR 5008 aims to create a pro-business environment, encourages job growth, and aligns Kansas with successful states. For these reasons, we urge the committee to pass HCR 5008. Thank you.
Thank you so much. And Eric Stafford from the Kansas Chamber. Welcome, Eric. Glad you're here.
Thank you, Madam Chair. Committee members, I'm glad I'm here too. Eric Stafford with the Kansas Chamber, here in support of HCR 5008. So just want to give some historical background to the first conference spoke about the REINS Act that passed last year. That was a big win in terms of legislative oversight on the rule and reg process. So everybody knows if you say the words lesser prairie chicken, everybody knows that you're talking about EPA regulations about an endangered species, or maybe not, right? Or is it endangered or not? And should the EPA have the authority through rule and reg power to enforce and place restrictions in areas in Kansas and other parts of the country that impact landowners and make compliance costs expensive? So that's a federal example. And this is what this constitutional amendment is looking to address. So when you have a state agency, we have a new administration, you hear about the new president, whether it was President Biden, President Obama, now President Trump, signing executive orders. And they're signing executive orders under rule and reg authority and under executive power that sometimes can go above and beyond what some might argue to be the scope or intent of the statute. And so this is where the constitutional amendment comes into play to ensure that we maintain a positive regulatory climate. Kudos to the reviser, saved me. I was actually sitting back there doing research. I'm like, how is the language different from 2022? And he did a good job summarizing how the language is different. So I don't have to get into that. But dating back to 2018, when the legislature first passed the requirement that state agencies have an economic impact statement, what is this going to cost individuals when this regulation comes into play? We've had to take some further steps, last year's REINS Act, because a lot of those economic impact statements don't have any cost to them. But they say, oh, not applicable. But as Representative Wassinger talked about with the work comp statutes, 3 of those flat out conflicted with state statutes. One of them changed the formula in terms of how you calculate the wages for an injured worker. And that is above the scope. When we already have a formula in statute, you should not be able to do that through rule and reg. And for either side of whatever it is, the issue that you're looking on, regulatory reform should be a bipartisan issue to protect from an administration that goes above and beyond the intent of what you guys pass as the legislature, no matter what the party is. So we believe that this is just adding stronger protections for Kansans and also protections for you guys to ensure that state agencies are doing what you guys ask. So I hope I'm under 3 minutes. I appreciate the time to be here, and I'm happy to answer any questions.
Yeah, you are. Thank you. Committee, so thank you for those 4 proponent testimonies. What questions do we have for people? Representative Carmichael?
Thank you, Madam Chair. Questions for my friend, the Chair of the Joint Committee on Rules and Regulations, where I serve as her ranking member, Representative Wassinger.
Yes, Representative.
Good afternoon. A
what can I tell
pleasure
you?
to see you in our committee. You made reference to regulations proposed by the Kansas Department of Labor that we heard in the committee approximately 3 years ago, as I recollect, and recognizing that I'm limited to 2 questions. First, my recollection is that the Attorney General revoked or rescinded his approval of one of the 6 regulations on the basis that a new appellate court decision had come down between the time when his office approved all 6 regulations and the time the joint committee heard the regulations. Is that not correct?
I believe it was 3.
Mr. Milholland staffs the committee, Madam Chair, and I'd make a request that he go back and try to determine for us what actually happened with the 6 regulations. My second question for our chair is, the fact of the matter is, none of those 6 regulations were ever adopted by the agency. And in fact, Department of Labor, the chair of the Commerce, Labor, and Economic Development Committee, the State Chamber, the Kansas Association of Defense Counsel, the Kansas Trial Lawyers, and a host of other people all got together after those 6 regulations were proposed. And as a result, we reached compromise legislation that was passed overwhelmingly in both houses of the legislature last year and signed by the governor that was acceptable to everyone and took care of all of those 6 regulations, which never became law. Is that not correct, Representative?
You know, Representative, the fact is that they could have done all of this without being stopped whatsoever. And that's why the legislature needs the ability to put a stop on things that didn't reflect legislative intent. And
take it
so
your
whether or
answer is
not
yes.
they figured it out afterwards, it says that we need the ability to say, you should not do this here. You should do it somewhere else. We shouldn't have to rely on all the parties to get together in a few months. We should be able to figure out how to take care of things when we can. That's why I said it wouldn't happen very often.
Madam Chair, I'll take it the answer is actually yes, that I did correctly recite the facts. Thank you.
Committee, do you have any other questions? Representative Osman.
Thank you, Madam Chairwoman. I have a question for, I suppose, any of the proponents. I suppose I can ask Representative Wassinger to come back up as it's her bill. I'm reading through this and I am trying to understand how this will actually work in practice. On the one hand, we are a part-time legislature and we're not in session for more than 90 days out of the year, which means 270 days out of the year, we're not here to oversee administrative rules and regulations, and we don't have the manpower or capacity to do so. So I don't understand how we would do that in the off-season in an effective and timely manner. But on the other hand, as we've established, there's no time limit here. There's no timeline in which there's a look-back period. So the legislature could look back years to any administrative decision that they want to make. And it says, in the sole discretion of the legislature, as in, we are not to be questioned and have no way to be overruled on anything. So how does this actually get implemented in practice?
Thank you, Representative. I believe that things would be done right away. We also meet throughout the year, joint administrative rules and regs. So it could be attended to any time of the year and then forwarded to the next legislative session. Obviously, yes, if we could look back many years, we could do that. But we've already enacted many different stipulations with agencies, asking them to go over their rules and regs every 5 years and tell us what they're going to revoke or get rid of because they're obsolete or they don't apply anymore with new regulations. So they're always going through those things, and we've made that a point to have that done. So I would say I would not think it would be more than 5 years ever. I can't think of anything that would, but that doesn't mean it wouldn't happen. Okay, thank you.
Committee, other questions? Representative Lewis.
This is for Representative Wassinger too. Thank you. Thank you, Chair. I have a question about the administrative state generally, and I think most people, I won't speak for everybody, but think that the administrative state, both at the federal and state level, has grown too far and gone too far. And I'm just interested if you're aware of the kind of the history there. That is to say, that there was a political science professor in the late 19th century named Woodrow Wilson, who wrote I think it was a book or a law review or an article called Administration. And he argued that our constitutional system of democracy doesn't work and that we really need to be governed by professionals, administrators. Are you aware of that?
I have heard that. I'm not intimately familiar with that, but I don't think I would agree with the writer.
Right. Do you view this proposed constitutional amendment as addressing some of the problems of the administrative state?
I do. The administrative state has grown exponentially, and we are a small citizen legislature, and we need to be able to reflect what our constituents want us to say. And I hear all the time from people how burdensome some regulations are and how they're asking so much more than they believe they should be asked for. And this is just something to give some checks and balances. I'm not trying to take over the administrative state, but I do believe the legislature has a responsibility to keep an eye on things, and this is one way to do it.
Thank you.
All right, thank you.
That was my one question. Can I have another?
Yes, you may. Yes, you may.
This is for another conferee. Mr. Temple. Thank you for coming today and talking to us about this very important issue. And I do believe this is one of the most important questions that this session of the legislature is going to address. You mentioned that we're one of 16 states without legislative review of regulations, right? And I'm just curious, can you talk about our neighboring states and how any of them are handling this issue?
Just briefly, I looked at Idaho, Arizona, and Virginia and kind of the steps they have in front of them as we were kind of digging into more of the research of that side. Do I have a specific example right in front of me? No, but I can follow up with you, Mr. Lewis.
I'd be interested in, for instance, knowing about our neighboring states and what they've been doing in this area. If you could get back to me,
Yes, sir.
Thank you.
Thank you.
If you could do that, and then you could let the committee assistant know, then she could get that information out to all of us. Would be helpful.
Absolutely. I'd be
Okay.
glad to.
Yep, thank you. Okay, committee, any other questions for any of the proponents? Okay, we also have written only from Randy Stuckey from the Kansas Grain and Feed Association, et cetera. Shahira Stafford from the Kansas Cooperative Council, Kelly Vanzewal from the Bankers Association, and Andrew Weems on behalf of Opportunity Solutions Project. We have a number of 7 opponent written only excuse me, testimony, so please take a look at all of that. Private citizens, and then also from the ACLU of Kansas. Take a look at all of that. Any other questions on HCR 5008? Sorry. Anyone? Okay. Okay, committee. Tomorrow, I had mentioned we might work some bills. I don't know that that's going to happen. Trying to figure out the best timing as far as working goes. I'm still going to hold it open, but I'm not, we might not work those bills tomorrow. We do have a hearing on 2 different bills. And then the committee, our committee, at the moment, we're hearing everything that we have, if that makes sense, that we've gotten back and that we can schedule, that I plan to schedule. There may be tomorrow, we may be able to add something to the agenda on Thursday. And if we have a lot, we might add something to the agenda on Friday. Just a warning, I'm still holding that open. Next week, you all saw how many bills were requested for introduction. And so we'll have to pick and choose, decide how we're going to do that, but it could be a very busy week next week too. So just if this week is a little lighter and we get out at 5 or sooner than 5, be thankful for that, because I don't know about next week. So, okay, anything else for the good of the committee? Then we're adjourned.